Sanctions have been imposed on 82 individuals and 29 companies. German payment provider Wirecard went bankrupt on Tuesday.
Russia has launched an unprecedented disinformation campaign against...
Billions of dollars have been found in various offshore accounts.
Welcome to Integrity Insights, the Berlin Risk Podcast. Hello everybody, welcome to the very last episode of Integrity Insights in 2025. I just recorded a conversation with Niels Appermont, a professor of economic law at Hasselt University in Belgium and a member of the Royal Belgian Football Association. Niels has been focusing in his work on the implementation of AML rules in Belgian football. Actually, you might be surprised to find out that Belgium is one of the only two EU countries, the other one being Bulgaria, that has subjected its professional football clubs to AML rules long before the EU has put football clubs in scope of its own AML regulation. The Belgian experience can therefore serve as a sort of a harbinger for things to come on an EU level in 2029 once the EU regulation takes effect. I hope you enjoy this episode. If you do, please take a minute out of your busy day to rate our show. All right, let's talk to Niels. Niels, thanks for coming on the podcast.
Thank you very much for having me.
It's my pleasure. Let's do the intro very quickly. Can you tell our listeners who you are and what you do?
I'm a professor of economic law at Hasselt University in Belgium, where I mainly teach company and commercial law. But I also have a research interest in sports law and everything related to football. So hence my research on this topic.
And Niels, I also just saw on your LinkedIn profile that you are a member of the Royal Belgian Football Association.
Yes, that's actually one of the reasons how I got into football research. A couple of years ago, a friend of mine who I studied with, who I did my law degree with, sent me a call, basically, which was launched by the RBFA. And at the time, they were looking for lawyers basically to populate their disciplinary organs. And out of interest, I just sent them my resume and an application. And at that time, they got back to me. And they basically said, we're now dealing with the fallout still of the Operation Clean Hands, the Operation Zero scandal, on which we'll probably talk some more in the next few minutes. And we're going to create something new, a clearing mechanism, in order to gain some more control on the invoices paid to player agents by clubs and football players. And we're going to create this clearing system to gain some insight on the financial flows and to make sure that these invoices and these contracts, that they don't violate the rules basically set out by the Royal Belgian Football Association. And if they're not in conformity, then we will not allow them to be paid out anymore. But we need independent lawyers to basically double check this mechanism, and we're going to create something called a clearing chamber. And I was in that clearing chamber for a couple of years.
I mean, we will talk about your research and the Operation Zero a little bit later on, but I wanted to ask you, based on your research so far, how big of a problem would you say money laundering is in football? Because that's not necessarily something that people connect.
It's actually hard to say. It seems to be that everybody is in agreement that it is a big problem. There's a lot of official reports saying this. There's also some reports from, for example, Europol, who dismantle AML and money laundering schemes or corruption schemes in football and in different countries in Europe. So it started out with a report in 2010 from the Financial Action Task Force, money laundering in football. But it also was confirmed through multiple reports by the European Commission and very recently in July 2025 by the UK Revenue Service. So basically everybody seems to be in agreement that it is a big problem, but it's very hard to quantify because of by nature very opaque, of course, and it's very hard to get a grasp on the exact numbers. But most reports speak of millions to billions of euros. But again, it's very hard to put an exact number on it.
And have you focused on in your research on any particular instances of money laundering in football, whether in Belgium or internationally?
Well, we focused specifically on the Belgian situation because our point of departure was basically the new Belgian legislation and how that would interact then with the football sector and how it would work or not, or which structural problems there might be. But yeah, of course, the Operation Zero scandal, which broke loose in 2018, demonstrated that there is a big problem, and it is also a problem, I think, of culture, that a lot of stuff which is deemed to be acceptable by some players and actors within the football sector, is actually not very acceptable when you look at it from a legal point of view.
Okay, so let's get into it a little bit. This Operation Zero, which you said broke out in 2018. What happened there exactly?
Well, basically the Belgian judicial and police authorities conducted a very wide investigation into money laundering, corruption, and match fixing into the Belgian professional football sector. And the public learned, I think, of this investigation in 2018 when a lot of searches were being done. I think more than 30 searches with players, coaches, referees, clubs. So basically, the police just entered their premises on the basis of a warrant, and they conducted a lot of evidence gathering. And then during those days, the information started to trickle out, and it turned out that later, I think 56 people were indicted. Some of them referees, some coaches, some players, some player agents. And at that time, Mr. Dejan Velkovic, who was a well-known player agent in Belgium, he opted to cooperate basically with the authorities in order for a reduction, in his conviction, for the penalty. And he basically laid out all these schemes that were being used also by him in professional football to basically try to fix games, to bribe referees, to bribe coaches, to engage in tax evasion schemes in order to have clubs pay players and reroute those payments through all kinds of shell companies and which were situated abroad for scouting. Exercises which basically never happened, but a lot of invoices were being paid to all kinds of foreign companies, and that money was then being rerouted back to Belgium, and it was then collected somewhere in cash in order to pay out bribes. So there was a lot of stuff happening at the same time. So it basically showed a culture of corruption basically within the sector. So it was a very big scandal at the time in Belgium. And of course, it led to reactions also from the legislator, which basically decided in the wake of that scandal to unilaterally then impose the preventative anti-money laundering obligations on the professional Belgian football sector.
And this was this scandal or the investigation, was it confined to Belgium specifically, or I suppose the highest professional football league in Belgium, or was this more like a European-wide investigation?
It focused on Belgium. So a lot of Belgian clubs and actors within the professional football sector were, of course, indicted. But what we saw in the scandal, of course, is that it didn't the operations weren't confined to Belgium. So these people were using, like I said, shell companies abroad, and they were paying invoices for scouting missions abroad, which in reality never really took place. But of course, those invoices seemed genuine and they could be paid by the clubs. And like I said, the money was then rerouted through all kinds of foreign shell companies, also within Europe, by the way, and eventually collected back in cash at Belgian banks. And then they were used to pay out salaries or to pay out extras to certain coaches. There was also this one story about a club official who received a Rolex watch for himself and his wife from an agent because he made a certain transfer happen, or a certain player was going to be on the pitch. So again, there was a lot of stuff happening at the same time. There was also this one game, a relegation game played by two Belgian clubs, where apparently the referee was approached also by these player agents and club officials in order to make sure that the right club was going to stay in the first division and the right club was going to relegate. Apparently even certain sports journalists were approached in order to write articles which would shed that referee in a positive light, even though he was going to make certain questionable decisions in order to cover it up. So again, as I said, there was the scandal exposed a big variety of activities, actually, none of which is very ethical or and most were also illegal.
And is it clear somehow from the investigations who was actually in charge of running these schemes? I mean, you keep mentioning the agents, so they clearly played an important role, but also the club owners, or who else was kind of like behind this?
They were all implicated. So the scandal mainly revolved around two agents, one of which was Mr. Velkovic, who confessed everything, but also a number of club officials were indicted, referees, coaches. But the problem was that later, when 56 people were officially indicted, a lot of them entered into plea bargains with the judicial authorities, and they paid a certain sum of money in exchange for not having to confess their guilt and not to be prosecuted any further. And afterwards, one of the investigators in charge also passed away. So currently the remainder of the investigation is still in a limbo. And looking back at it, it's very hard to actually determine who was actually guilty and who was not, because it's not the case that if you're suspected of certain criminal activity that you're automatically guilty. An investigation has to demonstrate that you actually are. But in many cases, these investigations later were never really carried out, were never really double checked. Most of these people actually never came before a judge, and certain procedures are still ongoing. The only public authorities which seem to have benefited directly from it are the tax authorities, because a lot of investigations were also done by them into the tax fraud dimension of the Operation Clean Hands scandal. And if I recall correctly, I think the Belgian tax authorities tried to collect something of 121 million euros in unpaid taxes or avoided taxes. And so, something came of it, but ultimately, I think not as much as one would have hoped when the scandal broke out.
Only a partial happy end.
Yeah, and a lot of the people who were actually implicated or suspected during this investigation, they are still active today in Belgian professional football. But again, it's very hard to determine who was actually guilty or who is not, because, they actually never came before a judge. It never came to a trial.
And so you Niels already mentioned that in response to these indictments and investigation, that the Belgian authorities voluntarily expanded the scope of the country's AML rules, as one of the only two countries in the European Union, along with Bulgaria, to actually include its professional football clubs among the so-called obliged entities for AML purposes. How did that kind of come about? Was it immediate? Was it like something immediate that materialized after these revelations, or did it take a while? And how was it implemented?
It took a little while. So the law was voted in 2020, and it has a little bit of particular history. So Belgium at the time was one of the countries which was still working on the transposition of the 5th European AML directive. But we had some problems with our government, in the sense that one of the majority parties had decided, for reasons totally unrelated to football or to this scandal, to withdraw from the majority. So new elections had to be organized, but what we still had in those days was a minority cabinet. So the political parties who were still running the government did not have a majority in parliament. And at the time, some of the parliamentarians, some of the people's representatives in our federal parliament, tried to include an amendment to then include professional football in Belgium's AML legislation, which was opposed in those days by our sitting finance minister, Alexander De Croo, who would later become our prime minister. So normally this would not have happened, as the government and the minister in charge were actually opposed to those plans. But since the government did not have a majority in parliament anymore, the parliamentarians could just vote on it, and that amendment was actually accepted by parliament. Hence, the professional football sector was included in Belgium's AML legislation. But under normal circumstances, this probably would not have happened, seeing as the government itself, the executive branch, was opposed to those plans.
So it was a kind of a coincidence, which also makes sense, because as we discussed, Belgium is only one of the 2 countries that actually has this type of legislation in the European Union. So that's interesting. I didn't know this background story. What would you say were this is something that you actually discussed in your paper that I think was published in November 2024 about the money laundering and compliance in professional football.
Yes.
And what would you say were the main challenges that the football clubs in Belgium faced when they, when attempting to conduct the required risk assessments that very obviously this whole framework was originally designed for financial sector. So one would expect there to be some challenges.
Well, the law, as I said, was adopted in 2020 and it entered into force in 2021, so roughly a year later. So the sector and the government, they had some time to prepare for its entry into force. But when it did, it turned out that there were still a lot of questions pending, and that was also uncovered by our research. So basically, who is subjected to AML obligations in Belgium on the basis of the preventative anti-money laundering legislation in football? It's the RBFA itself, so the federation, professional football clubs, and agents. But the law for the agents never really entered into force due to Belgium's federalized structure. So currently they're still not covered, even though the law says it is, but it just hasn't entered into force for them. But for the clubs and the RBFA, it did enter into force in 2021. And what we saw is that, of course, as you mentioned, AML legislation was originally developed for banks and financial institutions, and that led to certain questions about how the law then should actually be applied to football clubs. Well, for a number of cases, there was some clarity in the sense that the supervising authority in Belgium, which is the Ministry of Economic Affairs, the FPS Economy, entered into a dialogue with the sector, of course, and did some auditing in the first phase without handing out fines in case of non or incomplete compliance in order to get the sector up to speed. But there were also a number of structural deficits, I think, in the law, which made it very difficult for the law to be applied very smoothly to the sector. So, and one of those things was, for example, the client concept. So the Belgian law, which is based, of course, on European directives and on international FATF recommendations, states that obliged entities should identify and verify the identity of their clients. But who is a client of a football club? For a bank or a financial institution, if you open an account with them, it's quite straightforward that you are deemed to be a client. But football clubs, well, they have so many different activities and so many different actors they encounter in their dealings. And it was hard to see who can then be regarded as a client or not. So suppose that you are a spectator who just buys a match ticket for one day. Well, yeah, I think purely legally speaking, and if you apply conventional techniques of interpretation, well, that person is considered to be a client. But it's very hard, of course, for clubs to do KYC procedures on every single person buying a ticket. Same in case for player transfers, and of course agents, commercial counterparties. So some working methods had to be developed. But ultimately, it took until March 2023 for a royal decree to be published in the Belgian Official Gazette, which provided for some more official guidance. And it basically narrowed down the scope of this client concept and gave some guidance on who should be considered a client of a football club. And it turned out that the concept is interpreted quite widely, but one seeming glaring omission is the fact that investors and owners, so shareholders, for example, are not considered clients, which I think is a defensible interpretation. But specifically in football, they do represent one of the major AML risks by having laundered money being injected into football clubs by basically buying them or investing in them.
So who is considered a client then, if it's not the shareholders or the investors?
Yeah, that's something, like I said, that the Royal Decree of 2023 outlines somewhat. So who is considered to be a client? Well, certain spectators, if they deal with the club for an amount of 10,000 euros or more. So if you're buying business seats, for example, and the contract is worth more than 10,000 euros, you're considered to be a client. Other football clubs are considered to be a client, for example, in the case of a player transfer. Although you can ask certain questions relating to this setup, because if you as a football club are acquiring a player from another club, I think you are more their client than the other way around. But it's somewhat easier to understand if you have an outbound player transfer to another club, then another club is acquiring a player from you. So then that club can indeed be considered a client, but the legislation as it now stands covers both. Sponsors are also covered, agents, counterparties which are leasing a stadium, for example, or a part of it for an event, and also other federations, for example, FIFA or UEFA, when they deal with a football club or a Belgian football club receives money from them, for example, because of their participation in a European competitions, such as the Conference League or the Champions League, UEFA might in those cases be considered a client of a Belgian football club and needs to be subjected to these KYC procedures.
Interesting. And speaking about the sponsors, I found particularly interesting because we, as you know, we actually met at this Play the Game conference that took place a couple of months ago in Finland. And there, a lot of the speakers, a lot of the panelists there kept emphasizing the importance of illegal betting and its impact on the sector, and particularly the sponsorships of these usually Asian-based betting companies, their sponsorships of various European-based football clubs, and how this is a big kind of threat to the sector. Is this something that the Belgian AML rule addresses? If you say that sponsors are in scope, would for instance a Belgian professional football club be obliged to conduct a KYC on a potential sponsorship deal, and would they have to establish the ultimate beneficial owner of the company that wants to enter into that partnership?
In short, yes. And so sponsors of football clubs are considered to be clients according to the existing legislation in Belgium, and hence if a football club wants to conclude a sponsorship contract with, for example, a foreign betting company, that betting company will have to be subjected by the football club to all necessary procedures. And so identification, verification of identity, the identification of the ultimate beneficial owners. And then once the contract is operational, the club has to monitor that contract and has to look out for atypical transactions and transactions which do not fit the client profile. So what I think, because we also spoke to, when we did this our research, to one of the sponsors of the bill, of the amendment, which led to the adoption of the law in 2020. And he basically said, well, we also hope, of course, that this achieves the aim of cleaning up the sector a little bit. So to have football clubs double think and to think twice whether they would actually accept these sponsorships or not. So I think one of the aims of the legislator was also to have a little bit of a de-risking effect, whereby football clubs and other actors within the sector would just steer clear from certain deals which they would otherwise perhaps have made, but which they would deem too risky from an AML perspective, and hence not conclude anymore in the future. And that might then lead to a better image for the football sector itself, because Belgian football clubs are often themselves subject to de-risking and debanking efforts from banks and financial institutions in Belgium. A lot of them actually have a very hard time getting access to a bank account at an affordable rate.
And how given that you've spent a lot of time kind of analyzing this Belgian AML law applying to the football sector, how does it differ from the upcoming? We also already mentioned the upcoming EU regulation, which will put the professional football clubs EU-wide in scope as of 2029. We actually had a podcast, I think it was the 6th episode with Nick Raudensky that we published in June 2024. I would invite everyone to go back and listen to that episode. But what are the kind of like the main differences between those two regulations?
Well, there's quite a number of them actually. So the new AML regulation, which will indeed enter into force in 2029, and that itself is already an exception because the rest of the regulation will enter into force in 2027. Football got 2 extra years to prepare. But when it does, there will be a number of differences. First main difference is that federations, such as the RBFA, are not covered under the regulation, while the RBFA is covered under the Belgian legislation. So we'll have to see what happens. Secondly, professional football clubs are covered, but there are a number of exceptions in the regulation. So, for example, the regulation says that professional football clubs can be exempted if they play in the first division on the basis of a proven low risk for AML, which has to be determined on the basis of certain criteria put forward in the regulation, and a turnover of less than 5 million euros in the 2 preceding accounting years, which might already lead to certain type of fragmentation, especially in countries with football competitions which are not as big, where a lot of smaller clubs are also participating. And then there is also the possibility to exempt other professional football clubs playing in national leagues, which is not the first national league, also on the basis of a low proven risk. And there the second condition of having less than 5 million euros turnover disappears. So it's going to be a fragmented landscape, probably. And then professional football clubs are will only be subjected in 2029 under the regulation, under the AML obligations in case of 4 types of transactions: transactions with another football club, transactions with player agents, transactions with sponsors, and transactions for a transfer of a player. So, and also the owners, that's the final one. So transactions with owners and investors. So we see there are a number of differences. So the transactions with owners and investors will be covered also in Belgium, but also in the rest of the EU as of 2029. But for example, transactions with lessees or counterparties who, for example, rent out a part of a stadium for an event, they are not covered under the European regulation. And then finally, agents will also be covered under the regulation. Formally, again, this is also the case under the Belgian law, but due to Belgium's federal structure, the entry into force required an agreement between the federal government and the regional governments, and that agreement has never materialized. Hence, player agents are at the moment not subjected in Belgium.
Let me ask you one last question based on your experience with the AML framework in Belgium and seeing how this, because this is really like a unique situation that we have in the European Union. As discussed, Belgium is one of the only 2 countries that have had this type of legal framework in place. So this is an amazing opportunity to kind of analyze and see what has worked, what has not. And based on this, which is something that you have been kind of doing, based on your research, are there any kind of modifications or changes that you would like to see in the EU AML framework that will be implemented in 2029?
Yeah, it's a good question. I think that the restriction of the scope for professional football clubs to only 4 types of transactions, as I mentioned, transactions with investors and owners, player agents, player transfers, and sponsors, I think it's somewhat too narrow, actually. For example, I already mentioned the case of lessees and other counterparties who, for example, rent out a part of a stadium. Because what you see with AML, I think, is that, the dirty money always tends to look for the road where it encounters the least resistance. And so if you know that those 4 transactions are covered, you'll probably structure your dirty transaction as a transaction which is not one of those 4. So it's very difficult. I understand that this was the result of a compromise EU-wide to see whether to make it workable for football, but still it leaves some glaring omissions, as does the Belgian law at this point in time also does, because investors are not subjected. Secondly, I also understand the reasons behind the possibility to create exemptions for certain smaller clubs, but still it does somewhat distort the level playing field. And also when a club, for example, promotes to the first division and has a turnover which exceeds 5 million euros, then it will be covered. But if 1 year later it relegates again, then it might again not be covered. So it's very difficult, I think, to keep track of all this. It might have been better to also include in one way or another, in a certain role, the federations to gain some oversight on clubs, or to centralize perhaps certain procedures to make life easier for the clubs, while taking into account also their specific role. Because in Belgium, one of the difficulties is, for example, due to the fact that the RBFA is subjected. The RBFA has to provide licenses to Belgian football clubs. So suppose the RBFA now receives in Belgium accounting information from a certain club within the licensing procedure, and something smells off, then, of course, they would have to notify the Belgian FIU. But suppose then they say, you can't go ahead with this transaction, you can't, or we will not grant the license to this football club. Well, that's a financial death sentence for a club on the basis of a mere suspicion that something might be off, or AML money laundering might be taking place, and that will probably then lead to all kinds of legal proceedings between the club and the federation. So it's very difficult to take all these different interests into account. But I think that the sector and the legislation, in order to be effective, should make that exercise and to develop a framework which is actually more tailored to the sector. So what we'll probably see, or what I hope to see, that in the next few years, AMLA will develop some more specific guidance on how the regulation should be applied to the sector. And I hope to see some more guidance popping up there.
Okay. I mean, we still have about 4 years before it takes effect, so maybe someone will listen to us and make some changes accordingly. But Niels, I want to thank you for your time. I really enjoyed this conversation. There's actually very few people, I feel like, in the European Union who have this specific expertise. So I really appreciate that you found the time to join the podcast, and I wish you a Merry Christmas, as we are recording just before Christmas.
Thank you for having me. It was a pleasure.